Okay, I think I'm going to kick off. We are 1 minute past 3, and I know there's some people joining, but I suppose I'm just going to be giving some opening comments so we can allow people to enter into the Zoom and settle in as I go through some of the opening comments for today. So you're all very welcome to One Family's webinar, Building a Family Law System for Children. And we're very lucky today to be joined by a panel of national and international experts on family law reform and the voice of the child in courts service. A year ago, One Family held their first webinar on building a family law system for families. And today we're going to be looking at how to focus that even more sharply on the most vulnerable people in our society, children. And as I mentioned, we're joined by a really great panel with representatives from the Department of Justice, the Court Service, Trinity College, and from the UK to examine current plans and what the Irish system can learn from developments in other jurisdictions. So I'm just going to first of all run through a bit of housekeeping and then give you some opening comments from myself. So each of the speakers are going to be talking for somewhere between 10 and 15 minutes each, and we'll go through each one of them before we open up for Q&A. So please use the Q&A function throughout to submit your questions. And we will then have John Mark McCafferty, board member of One Family, who's going to host that Q&A at the end from about 4:40 onwards. To put those questions to your panelists. So keep them coming as we go, because he'll be able to theme them then and group them together and put them to the panelists towards the end of the event. One Family will be live tweeting the event using the following hashtags: family law, voice of the child, and law reform. So if you can share and like using those hashtags, that would be really appreciated. And I suppose then just to introduce myself, so it's a real honour for me to be here today in my role as Chief Commissioner of the Irish Human Rights and Equality Commission. But I also have a real connection to One Family. It's an organisation that's very close to my heart. I'm a lone parent myself, and I first came to know One Family as a service user many years ago when my daughter was born 20 odd years ago, and eventually ended up serving on the board and finishing up as chair just this year. So as I say, I'm a huge fan of the organisation, and I wanted to just call out Karen today, who is celebrating 20 years as CEO of One Family, which is a real landmark. But the organisation does incredible work by Karen and her team to work for people parenting alone, people in shared parenting, and people experiencing crisis pregnancy. And they have done so for many, many decades and really made huge impact on that community. So a huge thanks to Karen and her team for all the continued work of the organisation of One Family. The importance of today's event cannot be overstated, as put bluntly, the current Irish system of child and family law proceedings are not child, family or disability friendly. The focus on access to justice in today's discussions is one which the Commission echoes. Our current strategy statement places a priority on promoting access to justice, which is reflected across our litigation, our grant scheme, and our policy and research work. As Ireland's national human rights institution, we have asked the expert UN Committee on the Rights of the Child to question the state on access to justice for children. Specifically, we've recommended that the UN ask the state about its plan to provide specialised court facilities and whether it intends to amend the Domestic Violence Act 2018 to allow children to make applications for protection and safety orders in their own right. The current court system is marked by a number of chronic deficiencies, which mean that children in our family law system are often subjected to too much and heard too little. Delays in court proceedings, repeat adjournments, crowded lists, excessive caseloads, delays in conducting assessments of children and adults, inconsistent approaches to hearing views of the child, adversarial approaches to proceedings, inconsistency in decisions, and a lack of specialist training for judges and legal practitioners combine to see a need for a fundamental and significant reform. We at the Commission just yesterday finalised our legislative observations and recommendations to the Oireachtas on the general scheme of the Family Court Bill, and I know One Family played a leading role in the advocacy which led to this important legislation being included in the programme for government. The Commission has welcomed the stated aim of the bill to provide a more efficient and user-friendly family court system which places families at the centre of its activities, but we stress that there is a significant road yet to travel to secure that goal. Reform of the family court system provides an opportunity to place human rights and equality at the centre of the family justice system through the implementation of national and international human rights standards, including the Public Sector Equality and Human Rights Duty, the Council of Europe Guidelines on Child-Friendly Justice, the UN Convention on the Rights of the Child, and the UN Convention on the Rights of Persons with Disabilities. in the functions and rules of family courts. I know that we're going to hear from Liam about the general scheme of that bill and the work of the Family Justice Oversight Group, and from Emer on the modernisation strategy. That's the modernisation strategy that the court service is undertaking at the moment. So I think we should see today as a time to look at these opportunities, the opportunities that stem from that work. Now is the time for us to grasp them by understanding what does and does not work here and in other countries, by understanding who the system should be for, and how do we design it accordingly, by ensuring that we test, review and monitor what we develop to ensure that it is primarily working for children and their families. It is of critical importance that all of us, no matter whether we are a lawyer, policymaker, civil servant, service provider, parent, that we all take stock and reflect on how we can develop a system that is designed for families who need help, and most importantly, for the children in those families. We can no longer continue with the status quo. It's time for a radical reimagining of how to serve families who need legal assistance in Ireland through these opportunities now available to us. And today, as I've mentioned, we have a range of speakers who will help us to do just that, who will inform us, challenge us and share their expertise and insights. So before I introduce our first speaker, I just want to once again remind people to populate the Q&A with your questions and comments and thoughts as we proceed. And with that, I would like to introduce now the first of our speakers, Dr. Stephanie Holt from Trinity College, Dublin. So Stephanie is Associate Professor and Head of School in the School of Social Work and Social Policy in Trinity College, Dublin. Her research focuses on domestic violence with a particular emphasis on how children experience living with domestic violence and abuse and negotiate post-separation contact with domestically abusive fathers. Her research expertise involves engaging children in the research process with the objective of ascertaining and representing their views and experiences and informing best practice. She qualified as a social worker in '91, spending 9 years in professional practice before entering academic and research. So I'm going to hand over to you now, Stephanie, for your comments, please.
Many thanks, Sinead, for that introduction. Can you hear me okay? I just started my trusty timer. I can't actually see my presentation. I'm assuming it's loading there. I can't see it. Can other people see it?
No, I can't see it yet, Stephanie. Okay. I wonder if Maeve is working in the background, maybe to get it loaded up.
Well, maybe I'll just start with a kind of a general introduction, and you can let me know when it comes up there. So good afternoon, everybody. Delighted to see so many people in the room, even if it is slightly nerve-wracking that we're over the 100 mark. Many thanks to Sinead for the introduction, and to Karen and to One Family for inviting me to participate in this really, really timely webinar, as Sinead outlined, focusing on those child-centred reforms of the family law system we've been waiting for. As Sinead outlined, I have a particular interest, long-standing interest, I think, at this stage in family law, with a specific research focus on children's experience of post-separation contact, where there's been a prior history of domestic violence perpetrated by their father or father figure against their mother. I'm going to hold my hand up from the start of this presentation and acknowledge, I suppose, the very gendered nature of my research, which focuses on male perpetrators and female victims or survivors of domestic violence and abuse. That doesn't, of course, preclude other perpetrator or victim dyads, including female perpetrators, male victims and same-sex couples. This is, however, what I do. It is my focus, and it also reflects the gender nature of this issue as the predominant number of cases coming before the Irish courts and indeed internationally. I suppose while domestic violence and abuse is only one of the many issues that will be talked about today, as responded to by the family law system that demands reform, particularly when decisions on separation, divorce, custody and access are being made. I think it's important to note that it's not an insignificant concern, considering the international research evidence that at least 50% of those cases involve domestic violence and abuse. One would assume that while this statistic should demand that all parties to the case, which includes children and young people, are asked relatively routinely about domestic violence and abuse, the evidence, however, suggests that professionals virtually ignore the issue of DVA when considering contact or residency applications. This lack of attention to this ongoing harm to children post-separation represents, I would argue, and have argued before, a significant and dangerous shortcoming in the safeguarding responses to children. And it leads me to raise, as I have done in the title of my presentation, the question, is contact in the child's best interest? At the risk of answering that question before I've even started the presentation. I suppose the spoiler alert is that I do believe and argue that a meaningful father-child relationship is simply not possible. It's not attainable in the context of ongoing abuse. This is absolutely not about excluding men from children's lives. It's rather about prioritising child safety and welfare. A shift in emphasis, I would argue, is rather long overdue. I don't see the moving on button. Sorry. Oh, there we are. Okay. So in terms of an overview for this presentation over the next 9 or 10 minutes, I'm going to start with I suppose, one might say blue skies, but I think it's a relatively attainable look at what a new family system for children might look like, and briefly look at the evidence base on children, domestic violence and abuse, and post-separation contact, because a lot of it's out there already. I'm going to touch a little bit on some of the powerful assumptions and presumptions, some would call them myths and misconceptions, that underpin current decision making in the family law court in this context, and then briefly touch on what I suppose I see as needing to change.
Stephanie, you've gone on to mute. I think it might have been just when you were clicking on your slide there, maybe by accident.
Sorry about that. It was indeed, yeah. Okay, so I'm going to start with the title of this conference, which is Building a Family Law System for Children, and asking really of my presentation, you know, what does that look like? And sorry, this isn't moving on for me. It's not moving. Okay. And I think for a family law system to be child-centred, I would argue that this system really needs to engage with that question about what is it like to be a child and live with domestic violence and abuse. In asking that question, we really need to position children as central to the experience of domestic violence and abuse, and actively involved in the family's experience of that. They're clearly not passive bystanders, but they are individuals who embody domestic violence with all of their senses. They see it, they hear it, and they experience the aftermath in ways that are considerably beyond what adults often comprehend. Can you hear that dinging? Sorry, this isn't moving on for me. Okay. Maeve, I might ask you just to move it on because it's not moving for me. It's fine. Okay. So as a system that needs to understand DVA as coercive control, I think in recent times there's been this kind of notion of seeing domestic violence as separate to coercive control, and it's not. They're really one and the same thing. And in taking those as one and the same thing, there is a huge need to move from this physical instant model of domestic violence and abuse that talks about who did what to whom and when. That domestic violence and abuse for children is much more than the sum of its parts. There aren't any in-between downsides or episodes to this. This is a 24/7 white noise, as Stark referred to it as. And I suppose the foundations of that system also need to reflect an appreciation that child safety and best interests can't possibly be realised in a system that doesn't identify the risks that DVA presents for children, both pre and post separation, and doesn't position children as rights holders with a voice or a choice. So therefore, we're talking about it really needing to address this dangerous combination of invisible risks and invisible rights. Closely related to that, I suppose, Peter Jaffe's assertion that separation is not a vaccine against domestic violence. We need to fully embrace this notion of the toxic presence of the absent partner or parent post-separation. On the next point then, the system really needs to, I would say, to do some navel gazing and really interrogate how do we construct vulnerability and risk, and acknowledge that child safety cannot be ensured in a system that only recognises vulnerability from father absence and not the risk associated with abusive presence. And I suppose in doing that, two shifts need to happen. The first one being this shift from a selective attention to children's voices that only listens to them when they want contact but ignores them when they don't. And also appreciating that the voice of the child isn't simply out there waiting to be captured. It's much more subtle and complex than that. And I think the other shift that we need to make is this shift from focusing on adult rights, which is the next point, and children's capacity to really kind of looking at this child in front of us. So not a child, as in the universal rights or needs of a child, but let's have a look at this child that's in front of this judge at this particular point in time. And in doing that, moving from adult right to contact to children's right to safety, voice and agency. So if we can move that on, Maeve. Okay, so very, very quickly, because all of this information is in the public domain already. People know it. I know I'm pushing an open door with some of these statements, but I think nonetheless they need to be said. So looking at the evidence base on children, domestic violence, and post-separation contact. And I suppose the very first one there, post-separation contact facilitates the ongoing and often unmonitored abuse of children and the non-offending parent. And this is important because the initiation of contact proceedings is often merely a tactic used by the abusers to continue harassment and control over women and children. And that continues even in their absence from the family home, which undermines and damages the mother-child relationship. In many cases, as we know, rigorous pursuit of contact is not followed by any follow-up with visits or with remote contact for children. This for me calls into question, as I know it does for others, the extent to which their wish for contact is actually genuine. Related to that, in the context, particularly of the legal system, there is a culture, a rather dangerous culture, I would say, of disbelief when women talk about abuse. Many women report being advised by their legal advisors not to disclose domestic violence abuse to avoid being labelled implacably hostile. When allegations about fathering capacity are raised, they're most likely considered false. Children's wishes similarly are subjected to selective bias, as I mentioned earlier, taken into account if they want it, contact, but disregarded if they don't. I think also that this description of the legal system as a clumsy tool for managing complex family problems is something we also really need to consider, because the legal system does have a very, very limited capacity to influence the quality of contact experienced by children and the quality of post-separation parent-child relationships. As such, the law is very, very good at adjudicating on the logistics of contact arrangements, so time and place, but its ability to influence quality or indeed regulate the appropriateness of such contact is considerably much more constrained. The subtle, but I think crucial difference between making contact work or just making sure that it happens. And I think finally, that last point there, that children do not benefit from the ongoing presence of abusive fathers in their lives. There's clear evidence to support that. So the available evidence then would pose really difficult questions for me, as for many people here, about the risks and benefits of contact in the history of post-separation, in the history of domestic violence. And it leads me to reasonably question how decisions are made within the legal system about children's contact with domestically abusive fathers. And I think on the one hand, there are quite powerful assumptions and presumptions about what's in a child's best interest, but I think they're underpinned by really, really unhelpful and dangerous myths and misconceptions. So this notion that, the first of these, I suppose, this notion that contact is almost always in the child's best interest, that positive outcomes for children are dependent on contact. However, I would question if we don't critically really engage with this assumption that contact decisions are made may not adequately consider risk and arguably prioritise fathers' rights over children's safety. The second assumption considers the history of domestic violence not really relevant when it comes to the adults being separated. Indeed, I think this overwhelming judicial focus on the future renders the past irrelevant, even where those past histories involved abuse. And that really severs the relationship between domestic abuse and risk to children, which is quite dangerous. And also the parenting of abusive men can be gauged, the parenting capacity can be gauged without any consideration of their abusive behaviour. So that disappearance of domestic violence, quite dangerous as it is only actually one half of a double disappearing act that Radford and Hester talked about in 2015. The second half of that disappearing act is quite relevant for today because it considers the absence of children's voices or children's experience in the decision-making process. It's also, I think, grounded in a powerful assumption that involving children in the decision-making process or hearing their voices in this context is not really in their best interests. Okay. Counter argument to that?
Definitely.
2 minutes? Okay, counter argument to that from children who have participated in research is that they believe really, really strongly in their right to be heard, but don't actually want the power to decide. So I guess the critical difference between having a voice but not really having a choice. Sorry, maybe move on there. So I suppose one kind of guiding, and I'm trying really hard not to be very reductionist with this guiding principle, but sometimes simple is good, less is more. And in thinking about a guiding principle that considers the impact of domestic violence, I'm guided by my good friend and colleague, Davina James Hanman, who talks about, look at what the abuser's doing, look at what the impact of domestic violence is, and do the absolute opposite. And I think interventions and systems could learn hugely from that, because at the moment, they are part of the problem of making the child's or the adult's world smaller. They compound the problem because they constrain the choices from which there are limited options really for the legal system. So if we just move on a little bit, and I think within that, the presumption of contact is only 50% of the option. The other option should be a choice not to have contact. The second part in this is that if we're only looking at the adult stroke father's rights, we're only looking at 50% of the rights agenda because we're not considering children. Also, if we only look at the future, we absolutely delete a lot more than 50% of the history that's needed to make informed decisions. And I suppose finally, with capacity, we need to be interrogating both a father's capacity to parent post-separation as much as we're assuming that a child doesn't have capacity to participate in the decision-making process. Sorry, Maeve. And I suppose underpinning all of that is the need to uphold a child's right to end an abusive relationship. So my final slide is, I suppose, if the legal system, if we're reforming the legal system with a view to making children's world bigger, we need to be really committed to expanding what Liz Kelly called that space for action. You can't expand a space for action where you don't see children, you don't hear them, and you don't understand what they're experiencing. But if you do expand that space for action, you have an opportunity to open up a canvas that includes real opportunities for safeguarding, and not just safeguarding against risk, but also promoting welfare. And in doing that and expanding that space for action, we are opening up a space that prioritises children's voice, children's agency, and children's rights. Thank you.
Thank you so much, Stephanie, for your comments. It's obviously a really sensitive and difficult part of this whole discussion, and I think your presentation has brought a lot of clarity, I think, to some of the dimensions of it, so thank you very much for that. I see the questions pouring in, so it's brilliant to see so many coming in, and please do keep them coming. But I will continue on and introduce our next speaker, which is Liam Cohen, who is Principal Officer in the Civil Justice Policy section of the Department of Justice. His areas of responsibility include supporting the work of the Family Justice Oversight Group, of which he is a member. And prior to his move to the Department of Justice earlier this year, Liam worked in research roles in the statutory sector, and also spent time working in academia. And similarly, Liam, I'll give you a heads up when you're coming up to 1 or 2 minutes to go, and over to you now.
Thanks very much, Sinead, and thanks very much to One Family for the introduction to join with you today. I'm just going to set up my slideshow here and share. Okay. And there we go. Excuse me. So good afternoon, everybody, and it's nice to see such a large group of people here today. As Sinead said, my name is Liam Cohen. I'm from the Department of Justice, the Civil Justice Policy section in particular, and part of my role is to be a member of and support the work of the Family Justice Oversight Group, which I'm just going to introduce to you today, some of the work of the group and its aims and objectives, and where we hope to go in the department with family justice into the future. So the department launched its strategy statement earlier this year and its justice plan as well for 2021. The strategy statement ranges across 3 years, but one of the central goals of the statement is to improve access to justice and modernise the court system. And part of this work is to engage in activities which will significantly improve the experience of families interacting with the legal system at a time of great difficulty. Now, we know that many families interact in the legal system, in the judicial system, and they can do so for a range of reasons. But we're also acutely aware that there are many who seek judicial resolutions to family problems at very difficult times in their lives. So what we're trying to do is engage in pieces of work which can at least improve their experience as they seek resolutions. Two of the key areas of activity mentioned are the Family Justice Oversight Group, which I'm going to focus on today, and also the Family Court Bill, which my colleagues in civil legislation in the department are working on, and I'll say a few words about that as well. The Family Justice Oversight Group was established last year in September 2020, at the time actually when the general scheme for the Family Court Bill was published. Minister McEntee at the time established the group with a view to bringing together a range of the statutory actors and agencies in the justice area to try and improve overall access to and supports for families going through judicial matters. The membership of the group comprises representatives from the Department of Justice, including myself, I'm a member, officials from the Department of Children, Equality, Disability, Integration and Youth, and from the Department of Public Expenditure and Reform. We also have representation from the court service, including my colleague Emer, whom we'll hear about from later, and also colleagues from the Legal Aid Board. We are also very grateful to the Chief Justice for nominating 3 members of the judiciary from the district, circuit and high courts to participate in the group. And they provide invaluable insights to the workings of the group and their discussions, particularly on the practical aspects of how cases proceed. To briefly then take you through the terms of reference, the oversight group, its first term of reference and its really primary one is to develop and agree a high level vision and medium and longer term objectives for the development of a national family justice system. And I suppose one of the key goals arising out of this work will be the development and then subsequent implementation of a family justice strategy. And I'll talk about that towards the end of our presentation here today. The second term of reference then is to identify or develop the collaborative commitments necessary by agencies, largely the members of the group across the sector, for the development of a national family justice system, but also seeking to work with other agencies and organisations in the broader family space as required. To commission research to assist in the development of a national family justice system, and we're very fortunate that organizations and individuals who have made submissions to us already have submitted significant pieces of research for consideration, and I and some of my colleagues are reviewing this as we progress through the work of our group. And the final term of reference is to review and evaluate the effectiveness of the approach within 2 years. So within 2 years, taking a step back and seeing how the work of the oversight group has progressed, what has been the outcome, and where to from there. One of the key elements of the work of the oversight group so far, and it is important to emphasize that it's at a relatively early stage, is the consultation process. Minister McEntee, when she launched the oversight group or established it, placed a strong emphasis on a rigorous and robust and multifaceted consultation process, which would inform the development of a national strategy and subsequent actions. And we've developed a 3-phase consultation process in this regard. The first phase, which we initiated just before Christmas, we invited a number of stakeholders whom the group identified to participate in a Zoom meeting in January, and then to make a written submission to the oversight group on a number of different areas for consultation. We targeted as many organizations as we could identify, but also asked people in a kind of a snowball sampling way to circulate and push out the invite to other organizations. The range of areas that we asked them to consult on were things like the legal aid scheme, facilitating access to supports and services in the family justice sphere, how we can best or better hear the voice of the child and keep the child informed and involved in family justice matters, and a range of other areas, including mediation, alternative dispute resolution, and the role of technology in family justice in the future. The second phase has gone live, and it's currently live at the moment. And if you're not aware of it, I'd endeavour to ask you and the people that you work with and for to make a submission through our public consultation survey. Really, what we're seeking here are the experience of those who are or have been involved in the family justice system. And there will be a link at the end of this slide, and I think there'll be a link on the chat function as well at some stage too, which will allow you to go to the survey. We're really asking people to give us a sense of their experience directly of being involved in the family justice system. And we want to hear a range of things. We want to hear what worked well, if anything worked well, what you felt worked well, what didn't work well. And do you have any particular views on the process that you had to go through? And that might be in relation to the forms you had to fill out, or the time it took, or other aspects of the process that you felt are important to highlight. Where did you seek information? And how was it used? And where did you find it? What could be improved in the family justice system? What do you think the future focus of the family justice system should be? And also, one of my favorite questions, is there anything else that you'd like to say that you feel is important to highlight? And I think that's a really important question to allow people to really emphasize what is important to them. So again, I would take the opportunity just at this stage to seek out the survey. It's up on the Department of Justice website. Please, we've had a great response already, but it's open for another 10 days or so. And we'd really encourage everyone to try and respond as best they can to the survey. Stemming from some of the points that Stephanie would have raised as well in her presentation, the third element of the consultation is a dedicated, focused, bespoke consultation with children and young people. We are very aware that the focus of many family justice matters, well, not exclusively, the focus of many family justice matters are the children involved, children and young people. And in any system which seeks to improve family justice and the services and the system overall, the views of children are essential to this. We're very fortunate to be partnering with our colleagues in the Department of Children through their Hub na Nóg and through their participation unit there, and the expertise and experience that they have to develop a consultation process which will look at how children's voices can be heard through the justice system, but also the views of children to inform the development of the strategy. We are using the Lundy model, which I'm sure many of you are familiar with, to inform the structure and process and engagement around that child consultation. And it will begin shortly. And we're working with, as I said, working with the Department of Children to progress that. Just to briefly take you through some next steps then, I mean, we will, as you can imagine, have a huge amount of information through our consultation process to analyse and reflect on. And again, we very much have that already underway through the submissions received, the academic work which has been submitted to the group rather, for its consideration. We will also be shortly establishing advisory groups to support the work of the oversight group as it helps, as it really considers and reflects on the material which has been received through the consultation, to allow the advisory groups to provide additional input on the reflections of the oversight group, to maybe engage in some consideration of questions of the oversight group. And we're seeking to establish those shortly, and that would have been something that a potential that we had flagged back in January at our initial meetings with stakeholder groups. we will be busy writing towards the end of this year as well, as we begin to draft a national family justice strategy towards the end of this year and early 2022. I'm sure, as you'll all understand and agree, it's a really exciting piece of work. There has been reviews of family justice in other jurisdictions, and we're very conscious of that, but also very aware of having a family justice strategy, which is for the Irish context. And we're looking forward to hearing the views of the public through the consultation and through the views of children and young people themselves about how we take the national family justice system forward. So I would just take the opportunity to again ask you to take part and encourage others to take part. The Family Justice Oversight Group consultation link is there. If you Google Family Justice Consultation, it's there. And also, while I'm taking the opportunity as well, just to say that the department has also launched a consultation this week on a new domestic, sexual and gender-based violence strategy, which some of you may be interested in. And that is also underway and up until the middle of June. I might take a minute just while we have it, and I think, Sinead, I still have a couple of minutes left, just to talk about the Family Court Bill. As I said at the start, the Minister announced the establishment of Family Justice Oversight Group in September 2020, and at that time she published the general scheme of the Family Court Bill after the government had provided its approval for the drafting of the bill itself. The bill is a kind of another key plank of family justice work and was a key commitment in the programme for government for the Minister and the government. And it's a key part of really putting family centre at the activities of the justice system and seeks to provide access to specialist supports and encourages use of alternative remedies in family law proceedings. The bill itself will establish a series of dedicated family courts at the district, circuit and high court level within the existing structures. And it will also involve the appointment of judges on a full-time basis to the district and circuit court for periods of 3 years, and will seek specialist knowledge and professional training to support the work of the judges. The general scheme will also make a couple of other changes around jurisdiction, particular jurisdictions of the courts under the Child Care Act. Sorry, that's my own clock going off there. To allow more complex childcare cases to be brought to the Circuit Family Court, but specialist care cases will continue to be dealt with by the High Court. Work is ongoing by my colleagues, as I said, in civil legislation to develop this. It's not possible to say when the bill will be published or when it will pass through the legislative process in the Houses of the Oireachtas. I mean, we're still working within a COVID environment, but I know that everybody is working as hard as they can to make sure that the bill is the right bill when it's published and ready for the legislative process. The heads have also been submitted to the Oireachtas Committee on Justice for pre-legislative scrutiny, and that may take place as well. So just to give you an overall flavour of the family bill, the Family Justice Oversight Group, the two bits of work run in parallel along with other developments in the justice area to try and improve the experience overall for families seeking to access justice to resolve their issues. So I'll leave it there, Sinead. Thanks very much.
Thanks so much, Liam, for sticking to time and for a really interesting presentation. In particular, it's just great to see the strength of that consultation process that's happening, and also the cross-departmental collaboration that you're engaging in to develop this work. So thank you very much for that. We've, again, lots of questions coming in, so keep them coming. And I see we've been joined as well by John Mark McCafferty, who'll be handling questions at the end of the session. Okay, so I'll just go straight on to our next speaker, and that is Dr. Jan Ewing, Impact Fellow, Creating Paths to Family Justice from the Law School of University of Exeter. Jan is a research fellow in the law school. Her research over the past decade has centred on out-of-court dispute resolution processes, particularly the voice of the child in such processes. She's the academic member of the Family Solutions Group set up by Mr. Justice Cobb in 2020. With a brief to give fresh and focused attention to improving the experiences of and opportunities for separating families away from the family court. Her role on the Family Solutions Group was to review services to children. So I think within that, she's going to have an awful lot of really good insights to offer us where we are at the point in our journey here in this jurisdiction. And prior to entering academia, Jan was a family law solicitor and trained mediator. So over to you, please. Thanks, Jan.
Thanks so much. So if I can just share my screen, I'm hoping people can see that. See that screen? Yeah. Okay, great. So yeah, thank you ever so much for inviting me to join you today. As you've heard, I'm Jan Ewing from the University of Exeter, and I was the academic member of the Family Solutions Group. And the Family Solutions Group called for a reframing of our response to separation, but we're doing it from within a system that's a bit of a curate's egg, you know, it's good in parts. So how exciting for you to have an opportunity really to start, if not from scratch, well, certainly from within a system that doesn't have all of the constraints that we work within. So today I want to outline to you just a little bit about what I think we might have right in England and Wales, but also some recent reports that have shown that we do still have some way to go before the family system is safe for all children and their parents. So then what have we got right in England and Wales? Well, we've got the Children Act, which we've had for over 30 years, and that places the welfare of the child as its paramount consideration. We've had a well-established mediation profession for a number of years, and that's funded where eligible. And again, the welfare of the child is central to that. We have rules there that require the applicant to attend a meeting to hear about out-of-court dispute resolution processes before making an application to the court where that's safe to do so. We have CAFCAS, which is the independent body that represents the best interests of children in the family courts. We have a structure of rules and practice directions, which again, are very child focused. And place the child at the centre of that. And yet we titled the FSG report, What About Me? Because we were very conscious that, in fact, children's voices are often forgotten when decisions are being made when parents separate. So what about the pitfalls then? What have we encountered in England and Wales that you might wish to avoid? So I'll briefly look at three important recent reports. So the final report of the Private Law Working Group, the Ministry of Justice's Risk of Harm report, and the Family Solutions Group's work. So in terms of the Private Law Working Group, amidst really growing awareness about the significant harm that children can face when parents are in conflict, the Private Law Working Group found that the Child Arrangements Programme, which is the rules governing private law applications, really haven't been successful in some of their core messaging around encouraging parents to exercise decision-making for their children. They also found failures in the family court system to manage some domestic abuse cases appropriately. They reported that lack of public funding meant that many families enter a court system without any meaningful advice or legal practical help. And lastly, whilst good quality services exist to support separating families, including mediation, they found that there was little coherence in the delivery or incentives for families to actually access those services. So failings then around messaging, around safety, funding, and the coherence of support and the delivery of that support. So what about the Risk of Harm report? Well, similar to really your experience here, that concluded that too often the voices of children who've experienced domestic violence just go unheard, either through lack of consultation in the court process, or if heard, then they're muted in various ways. When they do happen, consultations are brief, and the pro-contact culture means that children are only heard when they're expressing a wish to have contact. And lastly, children are rarely consulted on how arrangements are working for them once an order has been made. And that underscores the importance, as recommended by the Family Solutions Group, of building in mechanisms for review and a legislative route for young people to whistleblow if they find themselves in a dangerous situation. And then the FSG report, it made a number of recommendations, but I'm highlighting just 3 here that might help shape how you build your child-centred response to parental separation. So firstly, messaging is so important. A coordinated national public education system is needed to help parents understand the impact of ongoing conflict on their children, and that how they separate will have a big impact on how their children manage the separation and thrive in the future. Secondly, there's a need to triage the needs of the family at an early stage with safety as the absolute priority. And thirdly, the FSG recommended a matrix of Article 12 compliant support services for young people so that their voices are heard in a meaningful way in practice and not only in theory. Just thinking about that public education message, this slide shows a newly launched campaign in England called the Parent Promise. And this is a promise that intact parents make to their children to put the child's needs first if they ever do separate. And of course, it's easier said than done once you have separated, but just getting parents to think upfront that there might be a better way of separating is an important step forward, I think. And then I've listed here just some of the stakeholders that will be key to get on board to make this, reimagined system work. So that includes, of course, parents, but also lawyers, the judiciary, the mediation community and other professionals working with separated families, potentially schools. I've been working with colleagues on the Family Solutions Group, and we've devised some lesson plans for teenagers around their rights when parents separate, which we've called the rights idea. And the lessons support young people whose parents have separated, but they also outline the alternatives to court so that hopefully that next generation and their children may have a better experience of parental separation. And the 2 organisations that support relationship education and citizenship teaching in England have just granted quality mark assurance to the resources. And in England, we find that there's a lot of good work is going on amongst professionals working with separated parents, but often in silos. So I'd really encourage you to think about how you can join up the response of all of those services that are working with separated parents. So as early as within schools, but also how about GPs? How about, your mediation services, your other out-of-court services and your in-court services? How could you make those more joined up? How could you make the messaging to all of these stakeholders consistent? In 2013 in England and Wales, to increase the uptake of mediation, public funding for legal advice on separation was removed, but it was retained for mediation. So now if you, only those who are victims of domestic abuse are entitled to legal advice that's funded by the state. And it was hoped that that would lead to an increase in the uptake of mediation. But lawyers had actually been important gatekeepers, for parents to hear about mediation. And the messaging around these changes was just communicated really poorly. And as a result, in fact, mediation starts fell 56% in that first year after implementation because the messaging was just not clearly done. So, please do learn from our mistakes, because money spent on ensuring that your messaging is right is actually money well spent. Next, I'd say to you, build your system on early triage of the needs of the whole family, because getting the right case into the right process at the right time is critical. So where there's safety needs, these must be prioritised above all else, and there must be accessible and affordable access to legal advice and to the family court on what we've termed the safety pathway. But in the absence of safety issues or other welfare concerns, well, actually court should be a last resort for parents. And instead, parents need access to information, advice, well signposted support to help them look beyond their relationship issues and their conflict towards the needs of the child, including the child's right to have a relationship with both parents where it's safe to do so. And we've called this the Cooperative Parenting pathway. And of course, the system needs to be sufficiently responsive so that cases can cross from one pathway to another if needed. I've highlighted briefly on this slide a project that Anne Barlow and I have recently evaluated called Mediation in Mind, which was funded by the Department for Work and Pensions. And it provided free of charge triaging of the separated parents' needs, legal information session, individual counselling for the parents and for their children, mediation, including child inclusive mediation, a session on communication and some group work. And this holistic package of support for parents and young people had impressive outcomes. And in the absence of safety concerns, promoting cooperative parenting with this holistic support, as the FSG report recommends, would ensure that parents are less likely to become embroiled in contentious proceedings. And the research evidence is unequivocal here. Parental conflict is psychologically damaging to children, and it impairs their relationship with both parents, often well into adulthood. Children's outcomes are poorer when parents remain locked in conflict. So encouraging cooperative parenting, where it's safe to do so, would steer families who don't need an adjudication away from court to less acrimonious solutions, and therefore improve outcomes for children. And at a time of rising court applications, it would help to reduce the burden on the family court. So then, why should we be listening to children? Why is this important? Because critically, I would say to you that you must be building your new system with children at the very heart of it, because the research evidence is clear. Young people want good information and support and a voice in the decision-making process when their parents separate. And failure to provide this compounds their sense of confusion and uncertainty. In our research on child-inclusive mediation, young people have told us that feeling listened to and respected in the decision-making process has been cathartic for them. Involving children in decision-making about contact is associated with a positive experience of contact. Arrangements are longer lasting, father-children relationships are better, and parenting is more cooperative. Hearing from young people improves their experiences of the process and the outcomes, and critically, as we've just heard from Stephanie, it ensures that those children are safe or safer. Yet in private law cases, children's views are sought via a CAFCAS report in England and Wales in only around 35% of cases, and only 26% of mediation cases involving children aged 10 and over hear directly from children. So we have some way to go in England and Wales. So I'd really, urge you to build a system that hears from children right from the outset.
You've about a minute left.
Thank you. And whilst the Family Solution Group focused primarily on parenting, as you can see there, that child-focused approach also reaps dividends in finance cases. And you're ahead of us in a sense, in that Ireland's already not only ratified the UNCRC as we have, but you've also ensured that that it's within your constitution that children's rights must be upheld. And we've not, certainly in England, Wales has, but England hasn't yet given a statutory footing to the UNCRC. And so again, I'd just say, really build on that and build children's rights into this new approach. Lucinda Ferguson from the University of Oxford argues that it does children a disservice to give them a right to be heard in theory unless in practice they can exercise that right. So in the FSG, we divided really the separating children into four cohorts. So cohort 1 was those children whose parents agreed care arrangements outside of state services, 2 settled in mediation, 3 applied to court, and 4 were separately represented within court cases. And then we looked at the individual information and support needs for each of those cohorts. And of course, you need to adapt this to your local context, but that might just be a useful framework as you begin to look at these issues.
Jan, just if you wouldn't mind wrapping up.
Yeah, so just to wrap up then, I would say to you, build that Article 12 compliant service. Prioritise safety for young people in that service. Where it is safe, then encourage parents to work together rather than against each other, and make sure that you provide properly resourced, well signposted, joined up information and support nationally, locally, online and offline, because without that support, then parents often will end up making an application to court. And just to finish then, I've added some hyperlinks to the various reports. So just thank you, ever so much again. I'm really excited to be learning from you and from how you do this over the next few years. Thank you.
Thank you so much, Jan, for a really, really rich and interesting presentation. I was particularly keen to hear about the rights-based approach used and the various different actors that you mentioned, thinking about schools and doctors and the roles that they play. And of course, as you finished up there on talking about the CRC, it's maybe important to note that the Scottish obviously have incorporated fully now in an act the CRC into legislation, so the most advanced obviously within the grouping. Maybe you could comment on that.
They have, although the English government is threatening to take that to the Supreme Court.
Okay, great. Okay. Okay, well, I'm going to move on to our next speaker. Just before I do, actually, just a reminder of the hashtags for today's event: family law, voice of the child, and law reform, if you're tweeting about the event, and once again to keep the questions coming in. But we will move now on to our next speaker, and that is Emer Darcy, the head of family law reform in the court service. So Emer has worked in the court service since 2004 and held a variety of roles in a mix of operational and support areas, including managing a family law office, HR, and leading the COVID-19 response team. She's now fortunate, and I love to hear this, to be doing her dream job, as she says, leading the family reform stream of the modernisation programme. It's an area of passion for her, and she says that together we will make changes to support better outcomes for people, families and children who are dealing with family law related matters. Emer worked in a range of other departmental roles prior to taking up this current one, in a variety of areas such as telecoms, aviation legislation, international security policy. She's volunteered for 20 years with the Special Olympics and recently finished a Master's on Leadership and Innovation in the Public Sector. Over to you, Emer.
Thank you very much, Sinead, for that introduction. And thank you to One Family for asking me to speak today. And can I just wish Karen a happy 20th anniversary, which would be great. So I think, Noel, you're going to look after the screen for me.
Yeah, it's up now, Emer.
Okay, perfect. Thank you. So what I'm going to do today is just really give you a context of the court service modernisation programme, to give you an idea of the approach that we're taking, the aspects that we're going to be looking at, and the time frame in relation to it. I'm just going to see if I can take control of the screen. I don't think I can actually. So Maeve, you might move on to the next slide for me. Thank you. So just to put the court service modernisation programme in a context for you, it's a long-term programme. The modernisation programme goes out to 2030. So we won't be having a few chats between now and September and then implementing an amended system by Christmas. this is a long-term approach to the reform of family law. There's a lot of activities already underway, but we're at the very beginning of this longer term process. So unlike the civil reform programme, which has a report with hundreds of recommendations in it, our modernisation programme has a lovely line that says reform family law. So that's the piece that we are picking up from. So the approach that we will take is that there's going to be progressive and incremental changes happening over the coming weeks, months and years. So it's not going to be a case of spending lots of time talking about things and doing nothing. We will be trying to take a different approach to how we go about this. So if you could move on to the next slide, please, Maeve, thank you. I'm including this because this is about the only photograph of me in known existence with my hair done. So I just thought I'd take the opportunity to put it out there. The team that we have in place, we've taken a different approach again in relation to this team. We have a multidisciplinary team in place from the very beginning of the programme. We have a subject matter expert in Alan, who's worked in court offices. Stephen has change programme and change management expertise. Niall and Aisling are bringing their IT development specific experience. And we're also getting support from our transformation partner, Deloitte, in terms of how we go about service design and transforming such a large area of work. So the next slide, please. This is the vision that the team has set for themselves in terms of this programme. So what has been happening up to date is that a piece of legislation will be introduced, and we would look at it and we would design a process and we would shoehorn it into an IT system, and we'd do training for people and we'd say, off you go. What we're doing this time around is that we are putting people at the centre of what it is we are going to do. So the people, the children, the families that the system is for will be the core of what we do. And what we want to do is to develop the system in such a way that they are best empowered and supported so that they can make their own choices about what's best for their individual circumstances. So for example, instead of a parent coming into one of our family law offices and saying, I want to make an access application, and be told, fill that out 3 times, sign that, bring it to this, go to a solicitor, go there, and immediately drive them into the court process. We want to take a human-centered design approach, and we want to understand what the needs of the people are, what they need to best consider what they need to do at that point in time. And that's quite a shift in terms of how we are developing our processes, our procedures, our buildings, the big picture of it. One of the most important things as well is that we'll be taking an evidence-based approach as we go through this. So, if something is working, great, let's continue it. If it's not working, either change it or ditch it and move on and try and find another option. Because we can't just put something in place and say, oh, well, that meets the criteria, let's move on. It has to work for people. And the fundamental outcome for all of this is that children, parents, family get the best possible outcomes for themselves in their circumstances. Could move on to the next slide, please? Thank you so much. So this is just to give you a flavour of how we're engaging with people in relation to the family law reform stream of the modernisation programme. So we started initially with consulting with staff because they are on the front line and they see the stress, they see the difficulty, they know what's working, they know what's not working. And they have identified quite a number of issues to us in a recent staff survey. 61% of them said that our buildings don't support people. 90% felt that our technology is not being used in an appropriate way to best support people. And they're also very conscious of the fact that we're not best supporting the broader needs that people have. So in addition to consulting staff, we're also starting to speak with a larger stakeholder group, including the judiciary, legal practitioners, but also to step outside the legal bubble and take that much more inclusive approach to understanding people's needs, be they cognitive, literacy needs, cultural issues, language issues, whatever that may be. So we're broadening that horizon of maybe the traditional stakeholders we would have spoken to. So from that, we're preparing this future state design of what we think family law services in the court service should look like. And we're using lovely terminology like agile and sprints. And we've actually just gone through one at the moment over the last week. And as we put together a prospective view on what this should look like, we will then be linking back in with users and with people and to support that with research and to validate what we're doing so that it's not a system designed by Emer and her team. It's a system that supports the needs of people. And it's only when we've done that will we be able to move into a position where we identify projects, future projects, and then move into delivery. And as I said, underpinning all of that is going to be ongoing data and analysis work. We're very conscious that there's gaps in terms of our understanding of the court process, how it works, what the impacts are. We don't even know whether we're giving people the correct advice and information at a particular point in time. So there's a lot of information for us to learn there. Next slide, please, Maeve. So this is just to give you an idea of the types of things we will break down into those individual chunks or sprints. This is really high level stuff. There's lots of those stuff that's not covered in here. It's just to give you a flavor of what we're looking at. So over the last 2 weeks, we've been looking at provision of information to the public, and I'll be able to give you a little bit more feedback about what we've done about that. We expect that the next area we're going to look at is in relation to buildings and facilities, because what we currently do is we tend to look at the court application, the court interaction in the courtroom, and maybe forget about the broader picture. We need to understand what it's like for people before they even come next or near a courthouse. What do they need? What's in place? What's not in place? And really, what's just going to make an extremely difficult situation just a little bit easier by asking those questions. Another area that we're going to look at is the courtroom layout, because a lot of courtrooms are heritage courtrooms. They have that very old-fashioned, I suppose, criminal structure within them. So that's a possible area of conversation we'll be having to see how can we change the courtroom, or should we change the courtroom so that people are stronger participants in the case that's going on about their own lives and their own children. We'll be looking at huge areas in relation to processes, digitization, obviously, how we can use digital to make things more supportive, but also being very, very conscious of the fact that digital is not the only solution. People have all kinds of needs and requirements that mean that we can't just force everybody into a digital situation, and that's absolutely not something that we're intending to do. And throughout all of this is a very conscious decision that we're going to design for inclusion, which is something we know we have not been good at. So that we understand people's language issues, we can, perhaps look at how we provide interpretation. How do we provide, if somebody has a sensory issue, why are we inviting them to court at a time when it's the most stressful, most crowded point? Is there an option for them to select a time of day that will allow them to be their best self when they go into court? Looking at cultural issues, the training that's needed for all those kind of issues. So if you can move on again, please. Now, this is just to give you kind of an idea of our timeline at the moment. So the team was established towards the end of March. What we have done, as I said, we've conducted that court service family law survey. We have done some international best practice research to get some ideas from the big picture. And I've taken note, Jan, of all of your hyperlinks. I think we've definitely found some of them, but we'll be looking at the rest of them. We have documented the high level existing services and operations, because that's something that's very inconsistent from one location to another. And that's also something we need to look at. We've also started looking at analysis on data. And as I said, we're beginning the engagement judiciary with staff and stakeholders. So over the last couple of weeks, we've been focusing on an area of the provision of information to the public in terms of what that might look like in the future. So we did work with staff. We have done work with some government agencies and departments. We have worked linked in with quite a number of advocacy groups to try to create a picture of what that future might look like, focused at all times on the best outcomes for people, families, and children. So I'll be able to give you a little bit more information about that and some of the ideas that have come out from those workshops. So because Hammond Lane is the built for purpose first family law court that will be built, that process, the planning and design process, is underway. There have been consultations. So in light of that, we're going to link the modernisation team in with the Hammond Lane team so that we can start looking at the best practice service design in relation to Hammond Lane and feed as much of that as we can into the building design. And that's as far as we've got in terms of our planning so far, because we need to regroup after this week and plan for the the courtrooms. But again, the key piece here is that we will be talking to people, hearing from people, understanding experiences, checking in with you to make sure that we've understood and that what is being suggested is actually solving the problem for people, reducing stress and just making things a little bit easier. Next slide, please. So here's some of the ideas, and there's one decision that I'm very proud of. So some of the things we're talking about, I suppose they reflect some of the things actually that Jan was mentioning, that we would, through either an app or website, that we would have a solution explorer or a step-by-step guide for people who could put in information about their own personal circumstances and be provided with information and links to supports. So if you are a parent, for example, who's seeking information on how to apply for maintenance because you are separating, that you would also be given information and links to parent supports, information on how to speak to your children about what's going on, how to support your children through your relationship breakdown. So it'll be a much more holistic picture of the family and their needs and requirements, rather than just telling them 3 of those forms, 2 of those forms, thanks very much. Trying to link up the existing resources that are in the system to best support people, and also to guide people to say, you know, this is complicated, you might need to seek legal advice, and this is how you go about doing that. You might need financial advice. So just to be able to give people pointers and ideas about what they might need to consider as they move forward in their own personal journey. That whatever way we provide the information, and as I said, very conscious that we can't just do this digitally, we have to support this through other means. But whatever way we provide that information, it will be designed to meet the needs of the family court users. So as I said before, that they can make their best decisions and they can understand what this is about, and that they can have better expectations. Because sometimes people come to a court office and they think that they can just get a domestic violence order there and then that the office can issue it. They don't necessarily, they're in a place of chaos and crisis, and they're concerned. So how we provide the information is obviously key as well. We have to understand the headspace that people are in when they come to talk to us.
You have about a minute left, Emer.
Sure, thank you. Another thing is that we would create a children's hub, very much linking in with the existing resources and the experts in this area, to figure out how we best support children who are either hearing about their parents separating, or perhaps want to speak up in court, or who are the subject of court proceedings. We're looking at obviously remote and digital ways of working, so that we can just make sure that people spend less time in a court building, because you know, it's not a grand day out for anybody to spend time in that very intimidating environment. And as I said previously, we'll make sure that the user need is feeding into what we do and what we build, particularly in relation to Hammond Lane. And the last thing to say is just that, you know, we have on foot of a suggestion by Deirdre, our office manager, Nina, who introduced us to the idea of being trauma informed. The court service has recently developed and piloted trauma-informed training, and it had got the highest and most positive response of any pilot program that we've run. So the court service has made the decision to become a trauma-informed organisation, and it will be mandatory training for all of our staff. And we're going to be rolling that out over the next year or two. So I'm on to my very last slide, and it's only a comment. So I just want to say that I think this is really exciting. I think we have been given the most phenomenal opportunity to look at this from scratch, and to take the opportunity to build a legacy together for our current and future generations. And I really look forward to working with all of you, collaborating with people, hearing from you. And I think together we can really make some great changes. So thank you very much.
Thank you so much, Emer, and your passion and enthusiasm is really infectious. It's just wonderful to hear it throughout your presentation. I used to work in the tech sector, so those words like agile and stuff, it's really interesting to see it. And what I can see is obviously a very innovative approach, very user-centered, which is really exciting and good to see. And that trauma-informed training, it's something that at the Commission we're promoting a lot in places like Direct Vision, the white paper, and the importance of trauma-informed approaches and trauma training for different groups. So really wonderful to hear about that. So we're slightly over time, and I think it's more to do with my waffling in between speakers. You've all been very good at keeping to time, but I'll introduce straight away our final speaker. And just a reminder that while Karen is speaking, that's your last opportunity essentially to get some questions in. Following her talk, John Mark is going to then do his best to group together those questions and bring them into themes which he'll put to the panel. So Karen, as I say, is our final speaker, and as I mentioned at the very outset, Karen is 20 years now in her role as CEO of One Family. She represents the organisation on the National Advisory Council on Better Outcomes, Brighter Futures, which is the National Children and Young People Strategy. She also chairs their subcommittee on child poverty. She sits on the board of the Courts Service, representing court users, and is the incoming chair of their Family Law Development Committee. So over to you, Karen.
Thanks for that, Sinead. So One Family is primarily a service providing organisation, although we have done some research and policy work in the area of family law over the years. We did research a number of years ago around the need for child contact centres in Ireland. We ran pilots on those, and then we had an independent evaluation that actually Stephanie Holt undertook for us. We have done Ireland's first shared parenting survey, and we have a lot of policy work on our website around different aspects of family law. We know it's a huge issue for the families that we work with, and we are doing our best to try and highlight some of the issues, and I suppose through this opportunity that we have in family law to gather voices and to look at, this year anyway, the needs of children. But a lot of what I would be saying is based on the experience of the actual parents and children whom we work with day in and day out in the organisation. So I'm going to start with kind of saying one of the issues we're concerned about is that we need clarity on the vision and the purpose of this reform. And I think this is echoed in the Ombudsman for Children Office submission as well, because who is the reform for? Because we've got a very robust general scheme for the legislation, but we don't have a scheme about the services that are needed, and we don't know who's going to develop them, fund them, run them. And maybe we don't need to know all of that yet, but we do need a central vision of the entire process. And in our view, that should be about child safety and the best interest of the child, because otherwise when we run into difficult decisions along the way, or there are various stakeholders with competing interests, it'll be hard to determine what to do unless we can keep going back to saying, well, actually, is that about child safety? How do we make the best decision here for children? And I think there's been a lot of, there's been really good inputs around the effects of children on different, I suppose, really difficult things that can happen in families and separation. And I just want to mention one of the things that's being done in Alberta, Canada. There's a woman, Diana Lowe, I think she's on the webinar actually, and she's been 30 years a family lawyer, and she established the Reforming Family Justice System. And it's a group with judiciary and other stakeholders, and it's well worth looking at their thinking. But what they're doing is they're working to transform the legal system away from adversarial court-based cases on family issues, because research on brain science has clearly shown that that system harms children. It's that black and white, that it contributes to adverse childhood experiences, which many of us who work in family support know all about. And instead of supporting families, the entire system, the culture, legislation, mindsets, causes harm to children and their parents. And to be honest, we think we see the same thing in Ireland. They can see that most issues that separating parents are dealing with are not legal at all. They're parenting, they're to do with the relationship and emotions, to do with finances, childcare. And all of those can and should be resolved outside court, and just bring the legal issues into court. And they have used the work by the Harvard Center on the Development of the Child, and they have a theory of change model about how to build resilience of children. So you're tipping away from getting into the adverse childhood experiences, and instead you're supporting the child and their parents to do better through skills and services, etc. So an interesting thing, a piece of research was done with the Canadian public and asked them about justice and access to justice. And stakeholders, probably like ourselves on the panel and people in the legal world, talked about things like speedier cases, the right to a lawyer, increased legal aid, simplifying the process, mediation, voice of the child, all really important things. But actually the public talked about the right to a good life, which is really interesting. So now what they're talking about is family wellness in all the family law systems and culture. And that's something that we can do here, because there's no doubt the brain science research is the same. And we have a unique opportunity, as I said earlier, to learn from other jurisdictions and to really get this right. So we need to challenge ourselves no matter what kind of stakeholder we are, to see, do we want to keep perpetuating? Do we want to keep participating in a system that's proven to be harmful to people? Or do we want to help imagine, design, and innovate an evidence-based system that will help families have that good life that they want? So I'm just wondering if my slides are going up, Noel. I had wanted the first one there a minute ago. If not, let's just go to the second one. Maybe I just have 2 slides. Yeah, so sorry, that one, as you can see, are just some quotes. One is from a mother who participated in our shared parenting survey a number of years ago. And clearly she's saying there's alternatives to going to court. And then Marion Campbell, who's a well-known family lawyer, also was saying in her experience about agreement, about trying to resolve things outside court. So we'll just move on to the next slide, if that's okay. So when One Family wrote our contribution to the Family Justice Oversight Group consultation, what we were doing was trying to create a system that would work better for children, that would be based outside court. And this is what we're calling a family law services model. So very much based on out-of-court family support services, strong assessment processes around the needs of children and the risks to children, and court as and when needed for the sharp end of legal issues. And this is based on our nearly 50 years experience of working and providing specialist family support services to people who are parenting on their own, sharing parenting, and going through separation. So at the bottom in the green, you can see there's this very universal approach about information and support. I think some of this has been echoed by other speakers, but this is just our take on it. And it's interesting when a number of organizations are coming up with similar ways, perhaps, of trying to resolve issues. But what we're seeing here is that there should be universal access to information and support through a website and helpline. So you want information about different pathways available to families, options, information about what a child-centered approach means, because that's what we're advocating here. There should be signposting to appropriate support services. And our own experience of running helplines is that really people may be quite upset and they may need some emotional containment and support on those kinds of calls as well, because ideally that would be the first port of call, is that you go and you get objective information in a supportive way, rather than going straight to court or seeking legal representation if you don't need it. In the pink, you'll see what we're calling Child Impact Assessment Framework, and this is the centerpiece of our model. And we're seeing that this should be completed by all families before they can access court, ideally. Now, there could be emergency cases in relation to domestic abuse or other issues, but even those families, we would see, ideally would still need to participate in this process to ensure the child's safety and best interest. And we're seeing there's 2 levels to this. Stage 1 is a safeguarding assessment, where there'd be a rapid desk-based risk assessment done in relation to the child with information from the family, including the child, from TUSLA, the guards, other organisations as appropriate. So you'd be trying to screen for safety issues. So you'd be screening around high conflict parenting, domestic abuse, child abuse, financial abuse, mental health issues, addiction, parental alienation, whatever might be coming up there. So it's very important, and it's interesting, this is what Jan was talking about, is does the family need a safety pathway, or do they need a cooperative parenting pathway? And then this should be reported to the court. And then the more thorough, longer term piece of assessment, we're calling the Child Impact Assessment. And this should be about identifying what the children need rather than what the parents want. And they could be the same thing, but they're not always the same thing. And the purpose is to develop a child-centered parenting plan that the family can then implement themselves. And this could be done readily. There's parents who will self-organize to do this. And then there's others who may require some interventions or supports. And both of those reports should inform the court if applications are brought. They may or may not need to be, depending on how they get on in this process. This work should be undertaken by professional, trained, supervised staff from an appropriate background, and we're calling them child court liaison officers. They could be called anything, but they should be linked to the courts. They should be able to make reports to court and be trusted by the courts. That's really important to make this work. So in the yellow, we're calling that area Specialist Family Support Services and Alternative Dispute Resolution. And ADR is something that has been strongly mooted around the Family Justice Bill, or the heads of the bill. And I suppose what we're saying is, depending on the issues identified in the assessment, family members may benefit, they may not, from some very specialist supports or general supports. And the kinds of things that could be included there could be therapeutic services for children and parents, parenting services that are skills-based, supportive, empowering of parents, child-focused, mediation and ADR that's child-inclusive. That should include shuttle mediation as well as joint sessions. Peer support for children, similar to what Rainbow provides, for example, peer support for parents, child contact centres, there's very few in the country. The pilots were closed down a number of years ago. Domestic violence services, including financial abuse support. And then there could be other specialist services around mental health, addiction, alienating behaviours, child abuse. And these services should be confidential, other than when they don't have to be, and very supportive for the individuals and families. But the outcomes or agreements can then be fed back to the Child Court Liaison Officer and to the court as appropriate. And really what you're trying to do here is develop the parenting plan and assist the families to be able to implement that particular plan that they have devised for their family. So in a way, we already provide a scaled down version of these services in One Family through our Separating Well for Children service, but this needs to be systematically developed and resourced right throughout the country for all families who need it. You can then see that there should be fewer cases going to court, or people just going to court to ratify agreements. There should be ideally less demand for courts, perhaps less demand for legal practitioners. There should be fewer adversarial cases and more demand for the family support services. And the court decisions, they shouldn't always be on the family to have to go back to court if those decisions are broken. Ideally, the Child Court Liaison Officer can have a role in ensuring that things are working for children, so that the onus is not always on the family. So this is ambitious, it's probably not perfect, but it's our version of what this could and should be aimed for at this stage. I'm just going to finish by briefly mentioning, on Monday, the SRI launched research on child poverty. And they did this using longitudinal data from growing up in Ireland. So they had a massive data set of children and young people over a long period of time. And along with the fact that we know that most one-parent families live in far higher levels of poverty than other families, and most poor children live in one-parent families, what we saw is that families are far more likely to move into consistent poverty when the relationship ends. So that means that the people many of us are working with who are parenting alone, sharing parenting or separating, are already living in or have just plummeted into serious levels of poverty. So this is just another part of the reality that we need to be aware of, so that we can try and provide the correct supports families need, so that the family law is not increasing their stress, but is helping families move forward. So, like others have said, we have a wonderful opportunity to really understand the needs of children and their parents, and to design the systems, services and legislations that serve them, so that we do not inflict long-term damage on them, but we support them to have a good life, which is what we all want. Thank you.
Thanks a million, Karen. And really just, I think similar to last year, your messages around where we are as a country, where we are as a jurisdiction, and what we can do to capitalise on the learnings that we see around us is just such an important message to hear, especially at today's event. So I'm going to hand over now to John Mark McCafferty, and I have a much lighter bio for John Mark than I do for everybody else. He's CEO of Threshold, the national housing charity, and a member of the board of One Family, and that's all I have. But I know that he's been in that role for about 4 years, and prior to that worked in the St. Vincent de Paul. I also know that he has walked many of the Munros of Scotland, and that he takes a hyphen in his name. So I'll hand over to you, John Mark, and I'll take control back with a minute to go so that I can just wrap up sharp at 5 p.m. Thank you.
Thanks very much, Sinead, and thanks for everyone's input, and in particular, thanks for the questions across the session. As Sinead says, my name is John Mark McCafferty. I'm one of the board members of One Family. I just want to say there's been a lot of questions at very, very high level of engagement, and we won't be able to get to all of them. So I guess what we've tried to do is kind of group together a number of questions. So first of all, just there have been a lot of issues coming up in the Q&A on the intersection of domestic abuse and parental alienation, with people expressing concerns from a variety of angles. false allegations of each, how children can be heard or believed, gender issues, how the unwillingness of a child not to spend time with a father, and incidents of probable violence. This can be interpreted as parental alienation, and then TUSLA may investigate with a view to reuniting the family, how best to protect those who have been victims of domestic violence, coercive control, parental alienation. So just, I guess, evidence, to show that children do better when they can maintain contact with children so as not to, or maintain contact with parents. So it's not more important that, or so I guess the question was, is it not more important to work towards cooperative parenting even where there has been abuse? So there's a number of issues there. I'm just wondering if Stephanie or Jan would like to comment on some of those kind of issues raised, because there's a whole kind of group of questions around those kind of things.
Yeah, I'm happy to go first, Jan, if that's okay.
Great.
Yeah, I mean, I've been watching the questions coming in while trying to listen also to the presentations, and there's a huge volume of them. John, Mark, you're right, and even trying to couple them together. You've done a great job there, kind of coupling them together. I think parental alienation clearly is a huge issue for the people who've attended. It's a big question for the people who've attended the webinar today. And I suppose for me, it's a very controversial topic that we don't really know enough about in this country at all. I was interested with Justice Keegan's comments on the particular qualification. I am delighted to see the Department of Justice putting out the request for tender on an international literature review on parental alienation, and I look forward to that coming in. I think it's scheduled to be in a couple of months, and to see how that might inform an evidence-based, I suppose, reform of the family law system. It's not quite an answer to the many questions, but I think in relation to children doing better when they can maintain contact with both of their parents, as an absolute, I would completely agree with that. And I was following the comments in the questions, and somebody had quoted a report where it said they do better with where there's a safe and happy environment for the child, and I think that's key for me. And there were some questions around, the termination of parental relationships. I think all of the evidence points to, yes, children do better when they have contact with both of their parents, but that has to be contextualized, and the context being that it's a safe and happy environment for the child. I was interested in what Karen said about the proposal for the reform of the system, and it's clearly not a one-size-fits-all, which is important, that people can be at different points along that continuum, as Justice Keegan said. So it's a very complex issue. Capturing the voice of the child isn't simple, particularly when we consider, as the commentators have had, about very emotive context, damaged relationships, which I think unfortunately tend to, those relationships that technically don't exist anymore can dominate, which is unfortunate. So that's a kind of I'm reading my notes here. That's kind of a one-size-fits-all answer. I'll hand over maybe to Jan.
Thanks very much, Stephanie. Just wondering, Jan, if you have anything to add there.
Yeah, I'd really echo what Stephanie says there, and certainly with the Ministry of Justice Harm report, they talked about the fact that if we listened more carefully and more consistently to what children are actually saying, so we don't mute their voices but we listen to them more, then we're going to get hopefully a better understanding of whether or not the allegation of alienation has any merit or not. So I think that's the approach, isn't it? And also, as Stephanie talked in her presentation about looking at this child rather than children, so we've got to look at this child and this child's needs. And if we listen to what that child is saying, and certainly in England, the Family Justice Young People's Board has been very vocal about the fact that often they just weren't listened to. It was assumed it was parental alienation when they were saying, actually, I'm frightened of my father. So, we have to take that really seriously, that there are children who aren't listened to. But equally, when we do listen to them more coherently and more consistently, then we're likely to get to the bottom of whether this is a a case of domestic abuse or whether it's a case of one parent alienating a child for whatever reason. So I think it's about listening to this particular child and not having hard and fast rules about children more globally.
Great, thanks very much, Jan. A number of questions for Liam from the department. I know it's difficult to get feedback on children's experience of the family law system due to in-camera rule, for example, but nevertheless, has the Family Justice Oversight Group taken steps to consult with children for their views, and has the Ombudsman for Children been considered as a partner organisation to carry out this consultation? So, and there's a couple more questions for you. I'll take that one first.
Thanks, John Mark. I might go back just very briefly just on the parental alienation bit. Stephanie alluded to, we in the department have commissioned a piece of work on parental alienation. The deadline is now passed for that. The aims of the research mainly looking at how parental alienation is defined in different countries, what it means theoretically, legislatively, and in a policy sense. What makes it distinctive from other issues within family justice, for example, things like domestic violence or coercive control, and what approaches or responses have there been in other jurisdictions to address parental alienation, and what evidence base, if any, is there for that? I know there were some questions of interest about that. So as I said, the tender deadline is passed and a number of bids have been received. The evaluation process is underway for that with a view to having a draft report towards the end of the year. In relation to your other question then, John Mark, around child participation, I mean, as I said in the presentation, we are engaging with the Department of Children and their participation unit here about how to ensure that we hear the voice of the child in the consultation process. I mean, that's still ongoing, and certainly I can bring to our colleagues in children the solutions or the suggestions provided here. I know that there were others in relation to the OCO as well. So I'll be happy to share those with colleagues and children as we progress that element of our consultation.
Thanks, Liam. And just maybe another question or questions for you there. How will the Family Justice Oversight Group develop and resource the kind of out-of-court family support services needed to ensure that children do not become trapped in adversarial court cases? And secondly, will adults who were once children affected by the justice system or family separation be consulted as part of the consultation with children?
To take the second point first, I don't think explicitly, but the public consultation is open, so they can certainly share their views there. And that last question will provide an opportunity for them to share their perspectives or highlight any particular issues that they want to highlight. They could always provide some contextual information at that point. In relation to the first question, I mean, it's still very early days in the work of the Family Justice Oversight Group. And I mean, it is a group that spans across the department, other agencies, other departments. So I don't want to prejudge or predetermine any considerations, but as we've heard today, and indeed from organisations One Family, we're very aware of the types of supports and services that are out there already, addressing many of the issues which I think many of our presentations have highlighted today are issues just around family and parenting support and enabling families to get on as best they can to do the job of supporting and raising, thriving children in a safe and secure environment. So it's still very early days for us in that regard.
Thanks very much. Thanks for that, Liam. And maybe just a quick fire kind of Q&A in terms of just what, in your opinion, is the most important thing we can implement in Ireland as part of the current reform system or current reform process to ensure child safety?
I'd say certainly one of the most important things is this early triage. Because if you get the triage right, and as Justice Keegan was saying, once it's entrenched and been in court for some time, it's so much more difficult to row back from that. So if you get the triage done well in the first place, then you can tailor the needs of that child and that family accordingly. So I think that's certainly key amongst many other things. Yeah, and I'd also say support for those families, because say in the Mediation in Mind project, just giving parents, telling parents to be responsible when they're hurt and angry doesn't work, but actually giving parents the support they need. So giving the parents who need some counselling. One of the mothers told me that, having had the counselling, she could deal with the emotional stuff in there, and it just meant that she could take the practical issues into her mediation. So it's giving the parents, it's, as you say, educating them as to the impact of ongoing conflict, why it matters that they're not in conflict, but also then giving them the support that they need to help them to get to the place where they can, do in practice what they've learned in theory.
Thanks very much. It's 5 o'clock, so I just want to thank the panelists for your very informed and cogent responses, and hand back to our chair, Sinead.
Thanks so much, John Mark, and thanks to all the speakers. Those, I think you managed to get through a lot of the different topics raised, if not the very specific questions put to us in the Q&A. Just a couple of small comments for me to finish. Firstly, this is being recorded and will be uploaded to the One Family website to be shared and rewatched. I would also encourage everyone to please participate in the Department of Justice public consultation, the details of which are in the chat, and which Liam talked about in his presentation. So that runs until the 11th of June. And finally, then, just to thank everybody, first and foremost, the speakers who've given such great time and expertise. You really have given us so much to consider today. Thanks also to Maeve McGrath from Trinity's Research in the Social Science Department for hosting the webinar and the tech support. So she's been working hard in the background to make things go smoothly. And thank you to all the organisers from One Family, particularly Noel Sweeney, who minded us all as the panelists throughout the preparation for this event. And mostly as well, not mostly, everybody's mostly, but lastly rather, thank you to all of you for attending, for being interested. And thanks to everybody who works every day to try to make the world a little better for a child. Thanks, folks. Cheerio.